A win that should have been simple until it wasn't. When the Ninth Circuit issued its decision in Baird versus Bonta earlier this month, Second Amendment watchers treated it as one of the biggest surprises of early 2026. A three-judge panel struck down California's decades-old open carry ban, ruling that prohibiting public carry violated the right to bear arms under the Constitution. In plain English, the Ninth Circuit, historically hostile to the Second Amendment, admitted the obvious. Open carry existed at the founding, was practiced through Reconstruction, and could not simply be erased by modern politics. That alone would have been enough historic news for a month. But then, something bizarre happened. Not only did the state of California petition the Ninth Circuit to rehear the case en banc, but the winner also asked for en banc review. The plaintiff, who just won, asked the court to wipe out their own victory and rehear the case before a much larger, much less friendly panel. That rarely happens. And in the 2A world, it might be a first. If you're new here, go ahead and subscribe. We cover the law, the cases, and the real-world impact, not the headlines. And this one deserves attention because a quiet procedural move at the Ninth Circuit could change how gun rights cases move toward the Supreme Court for years. Section 1. How we got here. Baird versus Bonta began in 2019 as a challenge to California's effective ban on open carry in counties with populations over 200,000 in population. California had progressively shut down open carry since the late 1960s, starting with Ronald Reagan's Mulford Act, in response to Black Panther demonstrations at the state capitol. First loaded open carry was banned, then open carry was banned in 2012. By 2013, California was functionally no carry without a government permission slip. The Ninth Circuit's January ruling reversed that, at least for the panel's moment. Two judges agreed the historical record was clear. Open carry was common, protected, and baked into both founding-era and Reconstruction-era traditions. Under Bruin's test, California produced no historical analogs to justify its modern ban. Absent that, the ban failed. For gun owners, it was the first meaningful Ninth Circuit win on carry in decades. For constitutional law, it was the textbook Bruin. Short takeaways. Open carry has deep historical roots. California offered no analogs, and Bruin demanded them. The Ninth Circuit panel applied the law as written. Section 2. Why the case mattered nationwide. Ninth Circuit territory is massive, stretching from California to Alaska to Hawaii. That geography alone makes carrying cases in the Ninth significant. But the real significance is procedural. If a Second Amendment case survives at the Ninth, especially post-Bruin, it creates a conflict with jurisdictions like the Second, Third, and Fourth Circuits that have resisted Bruin's enforcement. Conflicting circuits are jet fuel for Supreme Court review, and Baird could easily have become a vehicle for redefining permit requirements, open versus concealed distinctions, public carry in urban environments, government discretion in licensing. In short, Baird wasn't just about California. It was a national blueprint question. Does the Second Amendment protect the ability to carry without a permit? And if so, how far does that logic extend? Section 3. California pushes back. When California lost at the three-judge panel level, nobody in the 2A community was shocked by what came next. The state immediately moved to have the case reheard en banc, a legal maneuver that hands the issue from 3 judges to a much larger group, and pauses any momentum the winning side just gained. In the gun law world, delay is often as valuable as a win because it keeps the status quo in place while constitutional arguments get dragged out for months or even years. California framed its argument around public safety. They warned the Ninth Circuit that restoring open carry would cause chaos, fear, and instability, especially in busy urban areas. That messaging tracks with how the state has historically defended gun restrictions, not by focusing on text, history, and tradition, which Bruin requires, but by leaning into social predictions and emotional forecasting. Meanwhile, states like Nevada, Arizona, and others already have open carry without any of the doomsday scenarios California described. So California's move wasn't really about legal clarity, it was about time and optics. Rehearing en banc offers both. It slows down the road to the Supreme Court, and it signals to other anti-carry states that California intends to fight to preserve its licensing regime for as long as the courts will let it. Section 4. The twist nobody expected. The shot came from the other side. The plaintiff, the winner, also petitioned for rehearing en banc. That raised immediate questions. Why would you ask a hostile court to erase your win? Their reasoning? The panel acknowledged the unconstitutional ban on open carry, but sidestepped whether a permit requirement itself violates the Second Amendment. The plaintiff wants a broader ruling, not just permit required but allowed, but permit itself unconstitutional. In pure constitutional theory, that's correct. The founders didn't obtain government permission slips to exercise enumerated rights. No one applies for a permit to speak, print, worship, or petition. The parallel they drew: you cannot ban speech, then offer discretionary permits as an excuse to avoid First Amendment scrutiny. From a rights-based perspective, compelling. From a Ninth Circuit tactical perspective, dangerous. Section 5. Why this move is risky. Historically, Second Amendment cases die en banc at the Ninth. It has never been friendly territory, even with a shifting judiciary. Asking for en banc voluntarily gives the court two gifts. Time delay protects California policy. Forum, rehearing gives the Ninth a platform to narrow, reverse, or reframe Bruen. And in the hands of the Ninth, reframing is the real threat. Courts hostile to Bruen have openly experimented with ways to narrow its reach. Converting a clean win into a doctrinal experiment could actually make the law worse for nationwide carry litigation. There's another layer. Procedurally, a clean panel victory heading to the Supreme Court is far easier to defend than a contested en banc opinion, where the court is speaking with multiple voices, multiple concurrences, and multiple dissents. In litigation, clarity is currency. En banc destroys clarity. Section 6. On Banc History. For anyone new to appellate law, en banc is not just a procedural step. It is where most Second Amendment wins go to die at the Ninth Circuit. The court's historical pattern is unmistakable. A three-judge panel may recognize a constitutional defect, strike down a regulation, or expand the definition of a protected right. But once the full bench steps in, the momentum shifts. The legal standard changes from principle to politics, and victories become easier to dilute. In open carry litigation, the stakes are especially high. The Ninth Circuit has spent nearly 2 decades treating carry as an outlier right, not an ordinary civil liberty. That mindset shaped decisions on permits, training mandates, magazine capacity, and sensitive place zones. Baird disrupted that narrative by stating plainly that banning open carry violates the Second Amendment. En banc review now becomes the choke point where that disruption will either be solidified or undone. Key takeaways. En banc review is historically hostile toward 2A cases. Baird forces the Ninth Circuit to confront carry as a constitutional right, not a policy choice. This phase decides whether the win becomes precedent or is erased. Section 7. Permits versus rights. At the center of the plaintiff's petition is a deceptively simple question. Does a right require permission? For decades, California structured firearms policy around the assumption that permission and regulation define the boundary of acceptable ownership. Bruen changed that. Bruen held that the burden shifts back to the state, not the citizen, to justify any restriction using history and tradition, not sociology or speculation. The Baird panel opinion acknowledged open carry as part of the Second Amendment's text and history, but the plaintiffs want more than recognition. They want the court to acknowledge that even permit-based carry transforms a right into a privilege, because no other constitutional right requires government approval before exercise. No permit for speech, no permit for worship, no permit before possessing a newspaper or using the internet. The comparison is not rhetoric. It is a structural argument that goes to how democracy defines civil liberties. Key takeaways. The plaintiffs are not just defending open carry, they're challenging the entire permit philosophy. Bruen changed the burden of proof and exposed how little historical support permits have. If this argument succeeds, it reshapes both open and concealed carry frameworks nationwide. Section 8. California's strategy. California's petition is not defensive, it is strategic. If the Ninth Circuit keeps the narrow panel ruling, California loses open carry but keeps control over concealed carry systems, training, fees, and sensitive place designations. That outcome would be painful but manageable. If the panel ruling expands to include permits, California loses more than a statute. It loses its regulatory blueprint. By pushing for en banc, California seeks to move the entire issue back into a procedural fog where complex litigation thrives and public attention fades. The state's long-term strategy has always been the same. Avoid clean constitutional questions and force challenges to unfold across multiple lawsuits, each slower than the last. It is not about winning every battle, it is about shaping the battlefield so that victories arrive late and benefit fewer people. Key takeaways. California is playing long-game litigation, not short-term defense. Narrow losses are acceptable, structural defeats are not. This strategy influences Washington, Oregon, Hawaii, New Jersey, and other aligned states. Section 9. Supreme Court looming. Every major Second Amendment case now has a Supreme Court shadow. The justices have shown selective but decisive interest in firearms cases, particularly when circuit splits form or when lower courts sidestep Bruen. But the court prefers clean vehicles cases with clear facts, a clean procedural posture, and narrow constitutional questions. Baird could become the first pure open carry case to reach Washington, but the plaintiff's petition accelerates that possibility at a moment when the record may not be fully developed. That creates tension between winning winning fast and winning well. A premature vehicle risks muddying the carry question, confusing history analysis, or prompting a narrow Supreme Court opinion when a broad one might have been possible with more time. Key takeaways. The Supreme Court is watching, even if indirectly. Clean vehicles matter more than urgent vehicles. A rushed appeal could create a weaker nationwide precedent. Section 10. What comes next? Both petitions now sit before a court that knows how much national attention surrounds open carry. They can deny both petitions and keep the panel win intact. They can grant California's petition and narrow the ruling. They can grant the plaintiff's petition and escalate the permit challenge. Or they can grant both and reshape the entire case into something broader than anyone expected. No matter which path they choose, Baird has already forced a shift. It dragged open carry out of the shadows of concealed carry litigation and treated it as a constitutional issue instead of a policy debate. It forced California to defend bans using text and history, not hypotheticals. And it forced the Second Amendment community to acknowledge that rights and strategy sometimes collide in uncomfortable ways. Key takeaways. The outcome now depends on strategy, not just doctrine. Win or lose, open carry is now part of the constitutional conversation. The case proves that litigation in the Bruin era moves in bigger and faster cycles. The slow revolution. Constitutional change rarely looks like a single ruling. It looks like pressure points, trial balloons, petitions, denials, and unexpected wins from places nobody anticipated. Baird is that kind of case. What started as a challenge to an open carry ban now sits at the intersection of permits, history, litigation strategy, and Supreme Court timing. Gun policy is no longer just about laws. It's about who controls the conversation and how fast the courts are willing to rewrite old assumptions. Whether Baird ends in a clean win, a fragmented loss, or a future Supreme Court showdown, it confirms one thing. The Second Amendment fight has moved beyond the abstract. It now lives in paperwork, petitions, and en banc chambers. And the results increasingly shape how ordinary people carry in the real world. If you care about where the Second Amendment goes next, this is not a case to ignore. And if you're watching closely, make sure you stay subscribed because the next phase could arrive faster than anyone expects.